estate recovery funds. Let's start. There we go. It's going to do the same thing, isn't it? So question one talks about real estate recovery funds, and what it says, it's limited to what dollar amount. So $40,000 is the maximum amount that will be paid in the name of one licensee. So $2,500 is the amount that the real estate commission may fine per violation. And then $800 is the maximum amount of non-interest bearing loan that can be received for pre-licensing classes. So 1 million is the minimum amount that must be in the recovery fund. So when you say it's limited to what dollar amount, when it's in the recovery fund, 1 million is the minimum. So when we look at that question, 40,000 is the answer because that's the maximum amount that will be paid in the name of one licensee. So real estate recovery fund claims are limited to what dollar amount. So when they make a claim, so the fund has to have a minimum of $1 million, but a claim to it is a maximum of $40,000 per agent. Does that make sense?
Yeah.
Okay. So next question says, under what condition can an assistant talk with a client about the terms of an offer? So what do you think that answer is? Did I lose you? There you are. So under what condition can an assistant talk with a client about the terms of an offer? What do you think?
Under what condition an assistant to talk to a client about the terms of an offer?
Yeah. So if you have an assistant, what do they have to be able to talk to a client about the terms of an offer?
I don't know.
It would be the same thing. You have to have a license to practice real estate. So in order to talk to someone about the terms, you would have to be licensed.
Okay.
So that's what they're getting at, is that if you hire someone to be a inside sales agent or an assistant or anything like that, if they are going to speak to a client about any actual real estate terms, then they would then need to actually have a real estate license.
Okay.
So anytime you're talking to someone about real estate, you have to have a real estate license. Okay.
Okay.
Hey, Sharita. You're muted, and we're just kind of.
Sorry.
No problem. It's only a couple of us here, so we're just kind of going over questions. We're not doing the actual Kahoot right now because there aren't many people. There's only 3 of us in the room.
Okay.
So we're just kind of going over. And right now we're doing license, law, and rules, which is the state portion of the test.
Okay.
So, and feel free to chime in with any answers you have as well. So number 3, a seller gave her agent a check for getting her house sold so quickly. What must the salesperson do with the check? So if you sell someone's house and they hand you a check, what do you have to do with that check?
You got to give it to the broker. Okay.
Correct. You have to give it to the broker. So the answer is give the check to the broker, because the brokerage is the only only entity that can pay you for a real estate transaction. So any money given to you by a client has to go through the broker, then back to you.
Okay.
Great job. All right. The rate of commission that may be charged on the sale of an improved property is. What rate of commission can you charge on the sale of an improved property? And here's the thing. I'm making it a little harder because I'm not giving you the multiple choice answers. And so you know, think about what you know about real estate rules. Remember, this is license law and rules of the Ohio State Real Estate Commission. So what did they tell you about when you set a standard rate for commission? Can you do that? Is that legal?
I thought that was against the law.
That is against the law. So the rate of commission that may be charged on the sale of an improved property is what? What has to happen? It's whatever's agreed upon by the broker and the property owner. So it's whatever's in the agreement. There's no set or standard fee. If you hear that in the test where it says like there's a standard or a set fee, then you know that's an improper answer and it's against the law. So it's whatever's agreed upon by the broker and the owner. Because remember, in an agreement, the client is actually signing with the broker, not the salesperson. So always remember, it's the broker that is in the agreement with the client. So who can be affected by lead poisoning? Is it kids? Is it, I'm sorry? Say again, Janetta? You're breaking up a little bit. We lost Janetta. Well, it's everyone.
Yeah, anybody.
Everyone can be affected by lead poisoning. All right. What law requires a broker's license to be placed in close proximity to the federal fair housing poster?
Oh.
So it's the Ohio licensing law. So the Ohio licensing law requires that the broker's license be placed in close proximity to the fair housing poster. So when you hear that, so the other parts of that question, the Federal Fair Housing Act mandates that the fair housing poster be in the broker's office. So that's the Federal Fair Housing Act. It makes sure that the poster is in the broker's office, but the Ohio licensing law requires that the broker's license be close to the actual poster. At what point must earnest money be deposited into the broker's trust account? So at what point must the earnest money be deposited into the broker's trust account? So is it immediately once the offer is accepted, within 48 hours?
I thought it was immediately.
So a lot of contracts will say that it requires it to be immediately, and it's whatever the contract says. So remember, whenever you go into an agreement, into a contract, it's the contract is the rule on whatever happens in that transaction. So just always remember, if something is asking like how soon, what the closing date is, how soon earnest money is deposited, where the earnest money goes or who it goes to, that's all dictated. So it's whatever the contract states is what happens.
Okay.
So what lien automatically attaches to a commercial property to secure a broker's commission?
A broker's lien.
Is it an attachment lien, a mechanic's lien, a broker lien, or a judgment lien?
A broker lien.
That is correct. So a broker lien is the lien that automatically attaches on commercial property to secure the broker's commission. A closing occurred on September 30th, 2012. Under Ohio's licensing law, the soonest the broker can dispose of the file is what? How long do you have to keep a file?
5 years.
Janetta, what's your answer?
After they're done.
So you have to keep a file for 3 years. So it will be 2015. So just remember that all your files, anything that you have on a transaction, you have to keep those files for 3 years. Hang on just 1 second. I think a child of mine needs help. Hang on. Okay, sorry about that.
Okay.
Apparently they needed ice cream.
Absolutely. It's a sunny day.
Yeah. All right. So yeah, 3 years. So keep the files. The beauty of it is now you deal with mostly electronic documents. You're not dealing with paper files like we used to have. So you have all these boxes with paper files everywhere. So now you just keep it digitally kept in your drive folder for 3 years. And then once you know that date, 3 years later comes, you can dispose of it. Just know that if there's ever an issue up until that 3-year point, they can ask for all of your files. And if you don't have it, then you can be in trouble. Okay. All right. What protected group is covered under the Ohio Civil Rights Law, but not under federal civil rights law of 1968? Would it be national origin, handicap, ancestry, or sex?
I can't remember, but I think it's wait, let me see the question again.
So the question was, hang on. What protected group is covered under the Ohio Civil Rights Law, but not under federal civil rights law? So national
origin.
It is actually ancestry.
I'm always
Ancestry.
You were going to say it the first time. You had it. It was right there. I heard you start with and you just doubted it. So, yeah. So yeah. While national origin, handicap, and sex are covered by both statutes, ancestry is a protected class under the Ohio Civil Rights Law only. So that's the difference. All right. How many hours, where is it? How many hours of continuing education are required by an Ohio licensee over a 3-year reporting period?
30.
That is correct, 30. It is 30 hours, averaging 10 hours a year. So your first renewal will come on your first birthday after you're licensed, and then it will be every 3 years after that. All right. What must Brett's Brokers team include in their advertising as licensees working in Brett Foster's Ohio brokerage? So think of your advertising
Brett Foster's Brokers.
Yes.
Yeah.
Brett Foster's Ohio brokerage. So it would have to be the broker or brokerage name. So which transaction files from 1 year ago can Edward, an Ohio broker, dispose of?
No. Which transaction files from 1 year ago?
You said it would take 3 years, right?
Right.
None.
That is correct. None. Oh, receipt for personal expenses. So you can get rid of your personal expenses, but it's like I don't really consider that a real question, but yes, it's none. None of the actual pertinent documents from the file. Anything you spent for yourself on personal expenses, if you kept that in the file, you can get rid of that. So any receipts for personal expenses. And typically the answer is going to be none unless that's in there. All right. In Ohio, under what circumstances can a real estate broker pay a referral fee to an out-of-state broker? Now, this is a tricky one too, because I would actually get this one wrong. So the answers that they give, in Ohio, what circumstances can a real estate broker pay a referral fee to an out-of-state broker? Their answers, are the out-of-state broker agrees to claim it on their federal income state taxes. Out-of-state broker doesn't perform other real estate activities in Ohio, or the referral fee is less than $100, or the referral fee is less than $200. So their answer is that the out-of-state broker doesn't perform other real estate activities in Ohio. Now,
I thought it was none.
As long as they're licensed, if they're a broker, and it's an interesting one because, you know, I would argue that one just by having been in real estate for a while. I would argue that one. And the answer they want is the out-of-state broker doesn't perform other real estate activities in Ohio. So you can you can pay a referral fee to them as long as they're only active out of the state and they don't do any other business in the state. So homosexuality is protected under what federally protected class? Is it sex, familial status, or is it not protected, or is it national origin?
Is it sex? But I'm gonna say not protected. I don't know.
It is not protected.
Yeah.
It is not protected under any federally protected class. So the rationale behind that is there are local ordinances in certain cities that it is protected. However, it's not federally protected. Okay. An agent receives an earnest money deposit check of $1,500. It would be considered commingling of funds if the agent did what? What is commingling?
Put it in their
Didn't
bank
give
account.
it to the broker.
Yes, if they put it in a fund that is not their trust account. So commingling is when you mix money from your work with personal money. So funds means a mixing of earnest money accounts with other funds. So holding the check until closing may be a violation of law as well. So you can't just hold it, you have to deposit it. That's not commingling, but it may be considered conversion, which is theft. So if you hold it, you can be considered in theft. And if you deposit it into an account that is not your trust account, that is strictly for earnest money, then it would be considered commingling. What type of property is encompassed by Ohio's broker lien law? We talked about it earlier. There we go, commercial, right. So commercial property is under the broker lien law. Who does an agent need to notify for a change of his or her home address? Is it the commission, the local board of realtors, their broker, or the division of real estate? When you change your address, who do you believe that you would need to notify?
The broker?
Broker, commission, division of real estate, the local board of realtors?
Division.
Yes, it is the division. So the division of real estate is who you apply to for your license. And so anytime there's a change, you would go through the division of real estate. So whether you want to change brokerages and, change their change of address, anything like that, it would be through the division. Who approves the appointment of the ancillary trustee when a broker has died? So is it the division, the Department of Commerce, probate court, or the commission?
A probate court.
Probate.
No, that ain't right.
That's right. You're
Is
right.
it? Okay.
You got to go with your gut on these, Sharita.
Ah.
You've been getting them on the first try. Got to go with your gut. So yeah, it is probate court. So probate court would approve the ancillary trustee when a broker has died. So like any other estate, the appointment has to go through a probate court. When someone's died, that's who handles it. So the court of has jurisdiction over estates. All right. Under Ohio law, every listing agreement must have what?
A date, a closing date.
So diversity in housing logo, the company policy for the broker, a statement defining the practice of blockbusting stating that it is illegal, or a mandatory extension clause.
The logo.
It's actually blockbusting.
Oh,
Blockbusting?
that is so true. That's right.
Yep. So under section 4735.55, each written agency agreement shall contain an expiration date and a statement that it is illegal to refuse to sell, transfer, or rent property because of a person's race, color, etc. The statement about blockbusting must also be contained in the listing. So you're right that it had to have a date, an expiration date, and that it was illegal to sell, refuse to sell based on race, color, etc. And then a clause about blockbusting. Those are the things that have to be on there. So that's a brief snippet of what the license laws, when you're looking at the license laws, what you're going to be kind of dealing with. So, 30 of the 40 questions on the state exam deal with brokerage relationships and license laws and rules of Ohio Real Estate Commission. So get real comfortable knowing what the commission is, who handles what jobs, how people are appointed, how long they're appointed, any of your, license issues as far as like how much CE, how long between renewals, all those things are going to come up in your licensing laws. And remember, 30 out of the 40 questions, license laws and brokerage relationships. So we're going to go through brokerage relationships right now. And Sharita, this is because Janetta said that she was the only one, she was first. So she got to pick that we were working on state stuff today. So brokerage relationships. When can a broker reveal confidential information about a client?
Never.
Right. So it's only under subpoena when a court demands it.
Okay.
That's the only time. So you're correct. Any other time, they are not allowed to unless they are court ordered to do so. So that's the only time you can reveal confidential information about a client. A consumer guide to agency relationships form must be provided for all of the following except a single family residence, a condominium, a two-family residence, or an office building.
Office building.
That is correct.
Oh.
So what would not cause a real estate sales agent to lose their license? Violations of canons of ethics, second violation of fair housing law, felony conviction of embezzlement, or violation of the code of ethics?
The felony, I don't know.
Violation of the code of ethics. I don't.
It's, you
Violation
said
of
not.
the code of ethics.
Oh,
So the code of
Yeah.
ethics is with the actual law, and the canons of ethics are with the board. So the code of ethics is a code of professional real adopted by many boards. The code is not legally binding upon a sales agent. The canons of ethics are legally binding as adopted by the Division of Real Estate. A fair housing conviction and or a felony conviction are both grounds for revocation of a broker's license. So that's the only one that this is, remember, it says would not cause a real estate agent to lose their license. So this is with, code of ethics is with the board. So you're just talking about the board of realtors, whereas canons of ethics are the law. That's what the Ohio division, that's state law. So, and then all of these other things would actually cause you to lose your license. A felony conviction, a second violation. So remember, a lot of times in the questions, they'll use these to trip you up. So what would not cause a real estate agent to lose their license? Because I heard you say a felony conviction, you know, all those things, and they would, because, you know, you're thinking lose your license. So remember, they'll put words in as not or instead of or any of those things to kind of trip you up a little bit, because it's about reading the question thoroughly. A seller dies during a 90-day listing agreement. What is true? The agency agreement is terminated by operation of law. The agency agreement is still in full force and effect. The broker can sue the seller's estate for specific performance, or the sales agent can sue the seller's estate for specific performance.
By operational law.
Yes. So if a seller dies or a broker dies, and by operation of law, it means through the court. So if a seller dies or a broker dies, that's when a listing agreement may be terminated. Anything else would not cause the listing agreement to be terminated, as far as like a salesperson dying or something else, or someone dying in the house or any of that. Which fiduciary duty survives the termination of a real estate listing?
Confidentiality.
There you go. Good job. Confidentiality, it lasts forever. What is not a fiduciary duty of an Ohio real estate license? Obedience, so loan arranging, care, accountability, or obedience.
Loan arrangement.
Loan arrangement.
Yeah, not a fiduciary duty. All right. The relationship in which the agent is placed in the position of trust and confidence is described as? What's that?
No, just reading the question again.
We just had it in the last question.
Fiduciary duty.
There you go. Fiduciary. So it's when you're put in a place of position of trust and confidence, it's described as being a fiduciary. All right. When a salesperson is offering an overpriced property, they should not quote the price, quote only the listing price, discourage prospects from looking at the property, or tell the prospect what he thinks the price should be.
I would just,
But he represents the seller, right? That's what it said.
Yeah, when a salesperson is offering an overpriced property.
I feel like telling them what it should be.
So it's actually quote
Oh,
only
not
the
only
listing
the
price.
price.
So if you're showing a property, this
only
is
the
a
listing
buyer's agent. So if you're showing the property, you should quote only the listing price.
Okay, yeah, that makes sense.
Because if you don't say the price, then you're hiding information. If you discourage them from looking at the property, then you're steering. And if you tell the prospect what you think the price should be, then you're also influencing them. What is an ethical standard that must be followed by an Ohio real estate sales associate? Treat both buyer and seller equally. Treat all people as you would have them treat you. Treat all people honestly and fairly, or treat all people with honor and dignity.
All people fairly.
Right, honest and fairly. Because remember, your duty is to be honest and fair. So treat all people honestly and fairly is the answer. Because that's the standard. That's the ethical standard. So a sales agent represents a seller in a listing. What are the agent's duties to the customer, the buyer? So you represent the seller. What are your duties to the buyer?
The last question, fair, and
Yes. Honesty and fairness.
yeah.
Mm-hmm.
What is not the unauthorized practice of law? Completing a pre-printed sales contract form, preparing a real estate sales contract, preparing a real estate land contract, or preparing a real estate lease. So which is,
The real estate lease.
so it's actually the first one. Preparing a lease. So anytime you see the word preparing, it means that you're making the document.
Which is
Okay.
practice of law.
Right. That is the practice of law. So if you're completing a pre-printed sales contract form, then that's not the practice of law. You're just filling in blanks. Anytime you see the word preparing, it means that you're essentially making it.
Okay.
So just be careful of how they word that during the test. A broker lists a home. This agreement can be terminated by all of the following except death of the salesperson, broker bankruptcy, death of the seller, or death of the broker. So there's only one that it won't terminate the agreement. We talked about this earlier.
What was the answer again? Death of the seller.
Death of the broker.
So the
No.
death of the broker would terminate it.
That would terminate it.
So it would actually be death of the salesperson.
Okay.
So if the broker
Okay.
goes bankrupt, that would terminate because the broker is insolvent. Death of the seller and death of the broker are all items that would terminate. It's only the salesperson that if they die, they're not actually in the agreement.
Okay.
X lists the property. X finds a buyer. Is X allowed to write an offer as a buyer's representative? What do you think? Yes or no?
If you list the property,
So they
a
listed the
buyer.
property. They found a buyer. Are they allowed to write an offer as a buyer's representative?
That would be dual agency or something.
It would be dual agency.
Okay, so
yes.
I'm gonna say yeah, I'm gonna go with that. So for
Okay.
some reason I want to say no.
So yes, as long as both parties agree.
Okay.
So it would be dual agency. You just have to get it in writing from both sides, letting them know that you are in dual agency and that they are okay with it. So dual agency is legally allowed as long as both parties are aware.
Okay.
A buyer should never hear his or her real estate agent say which of the following: I cannot take that offer to the seller. I cannot withhold any offers, even poor ones. I cannot act as a dual agent per broker policy, or I cannot withhold hidden defects.
What was the question again?
A buyer should hear their agent say all of except one.
The first
There's
one.
only, yep, the first one. So I
Mhm.
cannot take that offer to the seller.
Oh yeah, you
Your
have
job
to.
is
You have
obedience.
to. Mm-hmm.
So if they tell you to take an offer, and I've told sellers this a lot of times, As a seller's agent, I tell them up front, if someone gives me an offer for $1 to purchase your home, I am legally obligated to give that to you. So don't shoot the messenger, because sellers will get mad at you and be like, why are you giving me these lowball offers? Well, I'm not giving you anything. The buyer is giving you that lowball offer. I'm just conveying it. So, just know that your job is obedience. And if you were asked to, if you were given an offer, you must present it. And on a side note, if you have multiple offers, what order should you present those offers in? Should
The
you
order-
hold any back?
No, the order
No.
they come in.
As soon as you get them.
Mhm.
Yep. As soon as you get them.
I do have a question. Okay,
Yeah.
so as soon as you get them, say you get to the third offer and then the seller accepts the offer, but you immediately got a fourth offer. I know you're supposed to tell them, but how does that go? Like if the seller signed the contract, is it the
Well, so here's some gray area. If the seller has signed the contract and you have not conveyed it to
Yeah,
the
it's
other
not binding.
side, it's still an offer and it's not a contract. So if a seller signs, until it's conveyed, it becomes a contract after it's conveyed. So let me clear up my words. It is not a contract until you have relayed that information to the other side.
Okay.
Once you have done that, then it is a contract. If you have not done that, then that seller can then review that offer, even if they physically signed or electronically signed, as long as it has not gone back to the other side.
Okay.
As soon as it goes back to the other side, you're in
It's
contract
binding.
and it's binding. And any offer that comes in after that, you would still present it to the seller. And then you would say to the seller, this could be a backup offer if you're interested in accepting backups. Otherwise, they have to go through with the contract.
Okay.
Now, it does give your seller leverage. If the buyer that's under contract, balks for any reason, say there's an inspection, they don't like something, or they're looking to nickel and dime them, then that seller can then say, I'm not interested in negotiating, and, go back to that other offer once that contract is released.
Okay. Thank you.
Who is not an agent or sub-agent? A salesperson employed by the broker, a broker who is listed in owner's home for sale, a non-licensed personal assistant of an agent, or a property manager managing property for others. So who is not an agent or a sub-agent? So which one is not? A salesperson, a broker, a non-licensed personal assistant, or a property manager?
The non-licensed, the personal assistant.
Correct.
Like you said, you have to have your license.
Right. So which would cause a real estate agent to lose their Ohio state license? Violation of the canons of ethics, violation of the code of ethics, violation of the Board of Realtors Code of Professional Responsibility, or a violation of a minor traffic offense?
Canons.
So canons of ethics, code of ethics, canons.
Canons.
Yes, canons is the law, code is the realtors. So
Okay.
a real estate licensee owes the fiduciary duty of confidentiality to the seller until.
It's forever.
Always.
Whatever.
Yeah, you don't.
Right. Until they're subpoenaed.
Oh,
So
right.
yeah,
Subpoena.
forever unless court order.
Okay.
What duty survives the termination of a listing?
Confidentiality.
There you go. All right.
Okay.
So based on these questions, how important is confidentiality?
Extremely. Yeah.
Right. So a sales agent is acting as a dual agent. The buyer asks the agent how much to offer for the listing. The agent should what?
Wait a second, as a dual agent, the buyer.
I'm sorry, say again.
I'm still just reading. I gotta read it
The
again.
agent should do the, what is it? I can't think of the word for it.
No, don't worry about the word. What should you do? If you're an agent and you're acting as a dual agent and the buyer asks, how much should I offer for the listing? What should you say?
The listing price.
That's a good one. And no.
Oh, dang.
So,
Boom.
so here's the thing. When you're a single agent working for one side, you're acting kind of like a coach. You can help that side win the game. When you're working for both sides, you are a ref. You are a referee. You have to be fair and impartial to both sides. So you are not allowed to suggest or recommend a price because you may know something from the other side. So you have to let them come to whatever they're going to come to. Now, here's what you can do. You can offer them comparables. You can say, here's what other homes are selling for that are similar. You can do that. You can do, that's about it. Because you can give them market information. You can't give them your information. Does that make sense?
Yeah, so you still wouldn't be able to just at least say, this is what the property is listed for.
No.
No. Okay. Got it.
So not offer any advice is the answer.
Okay.
So,
Absolutely.
because that's the thing. Like if you say the listing price, are you causing your buyer harm? What if you actually know that they could get the price for less? What if they could have offered 10,000 less or 20,000 less and the seller would have accepted?
Right.
So now by saying the listing price, you've caused harm to that buyer.
Okay. Got it.
Does that make sense now?
Yes.
Okay. All right. A broker and sellers enter an agreement whereby the sellers owe no commission if they find their own buyer. This type of agreement is what? What kind of agency agreement is this?
They don't owe.
If the seller finds their own buyer, they don't have to pay that listing agent.
That is the
I don't know that one.
So is it a net listing, multiple listing, exclusive agency, or exclusive right to sell?
Exclusive. Oh shoot.
Exclusive right to sell, exclusive agency.
I thought it was exclusive agency, but it might be the right to sell.
A net listing? I don't know.
So it is exclusive agency.
Okay.
So exclusive agency means that they're listing with an agent, but is not the exclusive right to sell. So if you have the exclusive right to sell, then that means that agent, it gets a commission no matter what. However it sells, that agent is owed a commission. Yeah, but if it's just exclusive agency, they're saying, we'll just use you as an agent, but if we find the buyer, then we don't have to pay you. Now, why do you think anyone would want to do an exclusive agency agreement if they don't get paid if the buyer or if the seller finds their own buyer? Why would you agree to that?
I would say it makes the realtor kind of hustle, so they can find a buyer first, so they can get paid.
It does.
Okay.
And here's the real thing about listings. Listings bring leverage. For every listing you take, you should receive about 2 buyer leads. So you should get about 2 buyer leads from every listing you take. And listings are a way to market yourself. So even if you don't actually sell that property, you've got a listing that you can then market your information out to everybody else. Because you can say, just listed, under contracts, just sold. You can market that. You can do open houses. You can circle prospect that listing. There are lots of ways that you can then get more business because you had that one listing.
Okay.
So that's why some people would take an exclusive agency as opposed to, just demanding an exclusive right to sell. So let's talk real estate. We've got, about 13 more minutes. Sharita, when's your test scheduled?
I gotta reschedule. I passed the state already. I'm trying to pass the national.
Okay. Oh, so we went over the
That's how you
state.
knew all the
It's
questions.
okay.
All right.
The information still kind of crossover to me.
Yeah. So let's see. So I'm gonna give you some hints on the national. So the national, which ones to study, right?
I kind of was lacking in probably calculations. There's some of them that it's not clicking for me. But
Okay.
yeah, I know which ones to study.
All right. So your 53 of the 80 questions are contracts, financing, general principles, and practice of real estate. That's the
Okay.
majority of that national portion.
Right. Yeah, I probably need to go over practices again.
Practice of real estate.
Yeah, and contracts.
Okay.
I only
Contracts and practice.
Yeah, I only got, let's see, it's 14 max, and I got 9 right.
On contracts.
Yeah.
All right, we can burn through some contracts real quick. So contract, and I'm going to just kind of go through these. We got like 10 minutes, so I'll just go through it quick.
Okay.
So contract law requires which amount of earnest money to be submitted in a sales contract. Now, remember what I talked about before. How much earnest money must be submitted?
You don't have to.
That's stated, that's in the contract between the
Right,
seller and
whatever
the
the contract
the
says.
contract says, yeah.
Right. So basically, it's no earnest money is required to form a contract.
Right.
It's just whatever the contract says. So
Right.
contract law requires which amount? None. You don't have to have any amount of earnest money, but it's whatever the contract states. So however they word that question, the answer is you don't have to, and whatever the contract says it must be. Which is not an essential element of a contract? Does it have to be in writing? Does it have to have
Yes.
offer and acceptance,
Yes.
both parties legally competent, or signed by the salesperson?
Signed by the salesperson.
Right. So everything else there is an essential element of a contract. Must be in writing, must have an offer and acceptance, and both parties must be legally competent. What does a bilateral contract mean? It's one that what?
2 people have something to
Yes.
accomplish,
Yes.
but to move forward.
It binds both parties to the agreement. So a unilateral contract only binds one person to the agreement. A bilateral contract binds both parties to the agreement. So it's just who is it binding on?
Mm-hmm.
A large mirror that a buyer wants to remain with the property should be disregarded as having no consequence, be identified as a fixture in the sales contract, be agreed upon verbally with its price stated in the contract, or never be included in the sales contract.
Never be included. Never be included.
Well, no, you can include those things. I do it all the time.
Okay.
Buyers want stuff, and you just basically put it in as a fixture. So you can identify it as a fixture and say that it stays with the property.
Oh yeah, because then there's that one part where they said if you showing the property, then everything should be out if it doesn't become, so that it doesn't become a fixture, quote unquote?
Yeah, if it can become a fixture,
Okay.
because that's the thing. Like anything that's affixed to the property in a way that makes it seem permanent is a fixture. So like say I have a television that I mounted on the wall. Because I bolted the mount into the wall, that mount is a fixture. Now, if the television is bolted to the mount, that television is now a fixture. Now, if it's a TV that I can just like unhook and take down like a picture and just like lift it off, it is not a fixture. So it depends on how it is attached. And if there's something that, you know, your seller is going to want, like that chandelier is from their grandmother, or, you know, there's a bookcase that, you know, their uncle handmade before he died, or whatever it is, take it out.
Right.
Because the buyers, it's going to be that one thing that the buyer's like, oh, I love this, I want it to stay, and it's going to become a sticking point. So you tell your clients, remove it, so that way, you know, it doesn't become an issue. And anything that's furniture that is not affixed is not a fixture. So if they have their furnishings in the house and their stuff, they can still say no if the buyer asks for it, because it's not part of the house. The buyer still has to ask for it in the contract. Now, that's the thing to be careful of as a listing agent. If they ask for it and you miss it, and that seller is attached to it, that could be a problem. So just know that you can include these things into a contract as a fixture. So you don't want to put prices of things in contracts that are not actual part of the property, because especially if there's a lender involved, it'll mess everything up. So the lender, yeah, the lender will look at it and say, okay, well, we have to deduct that from the price because that's not real property, and you're including that price in the buyer's agreement. So it has to be real property, and so that's why you call it a fixture. That way it's being conveyed at no cost. And that's what happens. It conveys at no cost. So it can be included. You never agree upon it verbally and just state the price, because anything you do has to be in writing. And then disregarding is having no consequence. If the buyer, you know, if they want it, then that's your job to at least request it. The scope and purpose of a real estate contract does not include the sale of a home, real property, fixtures, or personal property. So we just went over this.
Real property.
Personal
property. Personal. I meant personal.
Yeah. Yeah, only real property.
I can take.
So again, that not. We got that not in there. So that's the thing. All right. A legal remedy that would compel a vendor to execute a deed pursuant to a valid land installment contract is known as. So a legal remedy that would compel a vendor to execute a deed pursuant to a valid land installment contract is known as a specific performance. So here's the rationale on that. Specific performance is a remedy available to the buyer that would force the vendor, i.e. the seller, to execute the deed and specifically perform the promises given in the land installment contract. So when we talk about a land installment contract, someone's been paying on the land for a while. And then all of a sudden the seller's like, oh, I'm not going to sell it anymore. Then that buyer would then be able to sue the seller for specific performance, which means that you are obligated to perform what the contract stated. That's what specific performance is. We're suing you to perform what you agreed upon. Okay. In order to have a valid contract, the good faith deposit must be paid in the form of a cashier's check, cash money, a personal check, or anything the parties agree on.
Anything the parties agree on.
Correct. Anything the parties agree on. The first instrument a buyer usually signs in a real estate transaction is what?
The
Offer, I mean, the acceptance,
The
the
offer.
listing. Oh,
So it's a buyer. So a
Oh.
seller would sign the listing agreement.
okay.
A
Yeah.
buyer would sign the offer to purchase.
Oh, reread.
All right. Which is not an essential element of a real estate contract. Valuable consideration, offer and acceptance, good consideration, or lawful and possible objective.
Lawful and possible objective.
So remember, we said not.
Oh,
Not
not.
an essential element. So
good
valuable consideration,
consideration.
offer and acceptance, good consideration,
Good consideration.
right? Good consideration. So valuable consideration is the actual property itself, what the value is. That's the valuable consideration. So good consideration is not part of that. A meeting of the minds refers to offer and acceptance, consummation of a contract, consideration or closing of a contract.
Offer and acceptance.
Right. So offer and acceptance is the meeting of the minds. And what do they call that? It's a body part, something length.
Arm's length.
Arm's length.
Correct. Arm's length. All right.
Wish that was on the test.
If Ed purchases a property from Susan by an installment land contract, when will the title pass to Ed? When the deed is placed in escrow, when the deed is delivered to the buyer, when the contract has been signed by all parties, or when the seller exercises the liquidated damages clause.
Oh, I thought when a deed was placed into escrow, but it might.
It's when it's given to the buyer.
When
the deed is delivered to the
delivered to
buyer.
Yeah. So once they have received the deed, that's when the title passes.
Okay.
The basic requirements for an offer include neither objective intent nor subjective intent to contract. So it should be include either objective intent. So there's an N in there that shouldn't be there. I'll have to adjust that. Objective intent or nor subjective, it is neither. Neither objective intent nor subjective intent to contract, and it's objective intent.
Got me on that one.
Yeah, that might be a confusing question. I might take that one out. Number 12, let me make a note of that. 12. Okay. An option agreement is what? A unilateral contract, both bilateral and unilateral, bilateral or neither a bilateral contract nor unilateral. So think about what an option, like an option to buy. Who is it binding on?
The seller.
So the option is on the seller. And
no, the
so,
option is on the buyer because the buyer has the option to buy or not to buy.
right. So they're giving the seller, they're saying we have the first option to buy. Now the buyer can back out of that option, and so it's not binding on the buyer. So if it's only binding on the seller, then what is it? Is it unilateral, bilateral, or what?
Unilateral, because it's only on one person.
Correct.
Only on the seller.
Yeah.
Correct. Unilateral.
Ooh, I need to practice that.
So what happens to an initial offer from the buyer after a seller counters? So what happens to the offer?
It's
Rejection and
scratches
then
and go.
a counter.
Right. Right. That offer is rejected and is now null and void and no longer valid. When an offer is presented, the seller may what?
Counter offer.
What else?
Accept or refuse.
Correct. So they can reject the offer, They can make a counter offer, or they can accept the offer until it becomes a contract. All of the above. If upon a receipt of purchase under certain terms, the seller makes a counter offer, the prospective purchaser is relieved of the original offer, bound by the agent's decision, bound by the original offer, or bound to accept the counter offer.
The first one.
Relieved, correct. So a broker deposits a buyer's $500 earnest money check into the broker's personal checking account. The broker is guilty of what? We talked about it earlier.
Commingling.
Correct.
Mhm.
An agreement of sale is a contract between,
The broker and the seller.
it's the buyer and
Oh,
seller.
the
the buyer,
buyers.
yeah.
So think of it as a purchase agreement, the agreement of sale. So it's between the
Yeah.
buyer and the seller. The law requiring certain real estate contracts to be in writing to be enforceable is called what?
There must be in writing, statute of frauds.
There you
Yeah.
go, statute of frauds. Which are liquidated damages? A cashier's check, losses suffered when liquidating a business, an amount the parties agree on to settle a potential dispute, or paper money that has been soaked for 24 hours.
Maybe to settle a dispute. I don't know.
Right. Liquidated damages are the amounts between to settle the dispute between the parties. So that's what liquidated damages are. So there you go. You made it through contracts, and we're only 4 minutes over.
No, thank you.
I thank
Yeah.
you too.
Yeah, absolutely. Well, I appreciate you two being here.